Our sources today are pretty dense. We're looking at global legislative proposals, corporate compliance reports, some really explosive court filings.
Right.
But these aren't just dry legal papers. They are, in a way, blueprints for a future where machines are making decisions about our jobs, our health, our rights.
It's a lot.
It is. But the mission for this deep dive is actually pretty simple. We are unpacking the global legal crisis that's been caused by the, instantaneous adoption of AI. We're going to focus on why our traditional laws are just completely failing to keep up.
It really is the ultimate legal showdown, isn't it? Law is inherently slow. I mean, it's based on centuries of precedent, carefully defined terms, and human accountability.
And AI is the exact opposite.
The exact opposite. It's fast, it's autonomous, and it's constantly changing the definition of what a product is, or a defect, or even who can be an author. The friction between these two worlds is just enormous.
Okay, so let's start with a scene that should probably send a cold shiver down the spine of every executive listening right now.
Let's do it.
Imagine you're a senior manager, maybe in a really high-stakes industry, like wealth management or pharmaceuticals. Maybe you're in HR, handling top-level hiring.
So a job where getting it wrong is not an option.
Exactly. You've been using this sophisticated, high-risk AI system for critical tasks, maybe screening thousands of loan applicants or analyzing complex clinical trial data to guide drug development.
A system where, precision isn't just a regulatory checkbox, it's absolutely fundamental. If this thing fails, we're talking hundreds of millions in losses.
Or worse. And then the mandatory internal audit happens. You pull the logs, you trace a major recommendation, let's say a decision to greenlight a specific drug compound, back to the AI's output, and that's when you find it. The terrifying discovery.
Okay.
But the system is lying to you.
Wait, lying. Not just making, like, a math error. You mean actively fabricating facts?
That's right. This isn't a bug, it's what they call a hallucination. The system produced an output with these confidently stated but completely fabricated citations, metrics, and case references to back up its conclusion.
Oh, man. The digital fever dream.
Exactly.
So the output looks perfect, it reads well, it's all internally consistent. But if a human actually goes to fact-check the footnotes, they realize the system just made it all up.
The data points it cites just don't exist.
That is a nightmare, especially if you have to certify the accuracy of your financial disclosures.
It's so much more than embarrassing. It's a liability bomb. But here's where the problem gets exponentially worse. It's not just the algorithm failing, it's the people using it. We looked at data that suggests that over 10% of employee searches in public generative AI tools have involved pasting some kind of sensitive or confidential information into them.
Hold on. 10%. Dude, I have to pause on that.
Yeah.
Every compliance officer listening just felt a cold dread run down their spine.
I'm sure they did.
That's client data, personnel files, proprietary financial models, maybe even confidential memos about a merger being fed into public systems like ChatGPT or Gemini.
That's right. The employee might just be trying to summarize a huge internal document, to save time. Or maybe they want to polish a strategy memo before a big meeting, so they just paste the whole thing in.
But they're using a public tool that's scraping that data to train its future models. They lose control of it the second they hit enter.
Instantly.
Okay, so let's zero in on that, the immediate threat. What specifically happens legally in that moment when an employee pastes a confidential memo into a public AI tool? What line gets crossed?
You instantly trigger this cascade of legal threats, first and most critical. You compromise confidentiality, and you could waive the trade secret status of that information.
Right, because trade secret status requires you to make reasonable efforts to keep it a secret.
And if you just voluntarily feed it into a public third-party system, a court could easily say you failed that duty.
And that's a massive loss of corporate value. Your competitor could now legally use that information if it somehow got baked into a public model's knowledge base.
Exactly. Second, for regulated sectors like pharma or finance, you instantly undermine major compliance efforts. The FDA, for instance, requires strict control over clinical data. If that data is now somewhere out in the cloud, unsecure, you've lost control.
And this brings up that really thorny issue we saw in the sources, waiving attorney-client privilege. That's fundamental to corporate legal defense.
It is. If you paste a confidential legal strategy memo, say, your defense against an upcoming lawsuit, into a public AI to summarize it, you've essentially waived that privilege. You've disclosed it to a third party, the AI developer, and they have no obligation to keep it private.
The data control's gone. instantly, and your entire defense strategy could be compromised.
In a snap.
So this high-stakes reality leads us right into the heart of the problem. Why are our fundamental human-centric legal concepts like negligence and fault and causation, why are they completely breaking when they come up against AI?
That's the central conflict. The villain in our story isn't some malicious actor. It's the structure of the system itself. It's the black box.
Okay, let's detail this. When harm occurs, say an AI makes a discriminatory loan decision, why is it so hard for a victim to prove that a person did something wrong?
Well, it comes down to three things: complexity, autonomy, and continuous learning. Traditionally, if a product was defective, you could trace the fault back to a human action, a designer's error, a flaw in manufacturing.
You could find the person to blame.
Right. But with these autonomous AI systems, especially deep learning networks, the original designers often can't fully explain why the system made a specific decision.
Because they're constantly learning, modifying their own logic on the fly. It makes it almost impossible for victims to find the liable person and then prove that causal link between what a human did and the harm they suffered.
Let's use the analogy engine here because black box is a term we hear all the time, but what does it really mean in, daily life?
Think of it like this. Imagine a complex, self-modifying clock with billions of tiny invisible cogs. And every time it ticks, a few of those cogs rearrange themselves based on, I don't know, the weather outside. If that clock suddenly stops working and it costs you millions, you have to prove which tiny invisible cog buried deep inside failed. But not just that. You also have to prove why it failed. Was it because the clockmaker built it badly 3 years ago? Or because the clock taught itself a bad habit last Tuesday based on some weird data it ingested?
That's a great analogy. That distinction, who's responsible, is basically impossible to prove from the outside.
Exactly. The system's complexity means that if you're the victim, you can't really understand or describe the steps that led to your outcome. And if you can't be transparent about how a decision was made, how can you argue in court that the system is fair or non-discriminatory or even lawful? You're just stuck.
And adding fuel to this fire is the global regulatory fragmentation, our second major villain. If the black box is opaque, the regulatory environment is just chaos.
Total chaos. International businesses are playing whack-a-mole with compliance.
And it starts at the very beginning with just the definition of AI.
Right. There's no single globally consistent definition. The EU AI Act uses one definition. U.S. states are proposing their own different ones.
Right.
Countries like the UK and China don't even have a comprehensive statutory definition at all.
I mean, how are you supposed to comply if you don't even know what the thing you're regulating is?
You can't. And the regulatory form is just as chaotic. Look at the three big approaches. The EU has its comprehensive cross-sectoral EU AI Act. It's a regulation, so it applies directly across all member states, top-down unified.
But the UK is doing something totally different.
Completely different. They're not passing a big AI law yet. Instead, they've released 5 general principles and told their existing regulators, like the ICO for privacy, to just apply those principles within their own sectors.
Yeah.
It's decentralized.
And then you've got the US, which is just a mess of everything. White House executive orders, state laws like the new Colorado AI Act, and then existing agencies like the FTC and EEOC saying, hey, our current authority already covers AI.
It's a totally scrambled attempt to regulate something that's moving at exponential speed. And speaking of speed, governments are not waiting for the rules to be sorted out. They're deploying high-stakes AI right now.
Give us an example of that.
Well, the sources noted that Albania, in an attempt to combat corruption, appointed Diela, the world's first AI-powered minister, a virtual minister of public procurement, in September of 2025.
An AI minister.
A non-human government member. Its entire job is to handle complex public procurement decisions to ensure they are 100% incorruptible.
Wow. So the AI is evaluating bids, flagging potential conflicts of interest, checking against historical data.
Precisely. It shows that governments see the potential, but it also highlights the problem. You're deploying an AI to handle billions in contracts, but the liability and redress rules aren't even in place yet.
So what does all this fragmentation, the chaos of definitions and legal forms, what does it ultimately mean for an international business just trying to stay on the right side of the law?
It's an immediate, severe operational headache. It forces them into what's called the highest common denominator compliance approach. They have to design their systems to meet the strictest standard that applies anywhere they do business.
Give me a concrete example of that.
Okay, say you're a global HR platform building an AI tool for employee evils. In the US, you have state laws like Colorado's demanding bias prevention. In the EU, you have the AI Act. which requires mandatory fundamental rights impact assessments. You can't build two different versions of your product.
So you have to build one system that satisfies the EU's rigorous risk model and the U.S. state laws on bias prevention at the same time.
Exactly.
Yeah.
And that inherently stifles certainty. It slows innovation because you're constantly navigating this labyrinth of inconsistent rules. The overhead is just immense.
So if regulatory chaos is the villain, then the quest becomes building an internal governance fortress to contain all that risk. How are companies even starting to tackle this?
We're seeing this massive preemptive shift toward a governance-first strategy. The reports show that AI governance is now a top 5 strategic priority for 47% of companies. But here's the truly mind-blowing stat.
Okay.
30% of companies that aren't even using AI yet are already building out their governance programs.
No way. That's incredible. They're building the safety protocols before they even turn the systems on. They're planning for the fire before they buy the matches.
That's it. They're anticipating the legal requirements and embedding them into the design phase, and the core tool they're all relying on to build this fortress.
The AI Impact Assessment, or AIA?
Yes. These are becoming mandatory all over the world. The ISO 42001 standard, the EU AI Act's Fundamental Rights Impact Assessments, California's new rules, they are the foundation of compliance.
I have to stop you there because for anyone who's not in compliance, this just sounds like another layer of soul-crushing bureaucracy. Is it just slowing things down, or is there an immediate, tangible return on doing this?
It definitely sounds like bureaucracy, but its immediate ROI is protection against catastrophic liability. Let's go back to the analogy engine. Think of the AI impact assessment like a mandatory concussion protocol in a high-contact sport.
Okay.
You don't wait until a player's on the ground to figure out the rules. You mandate the assessment before the play. You assess the risk, you identify safeguards, and you make sure the system aligns with your legal obligations like non-discrimination and privacy before you deploy it.
So if a regulator asks, did you consider the risk of discriminatory impact? The AIA is your documented proof that you didn't just consider it. You assessed it, mitigated it, and you're monitoring it.
Exactly. And the good news is, for most companies, these aren't brand new, totally separate nightmares. They're leveraging existing privacy governance structures.
So you're just adding AI-relevant questions to the privacy impact assessments you're already doing for things like GDPR.
That's the easiest path. You just expand your existing DPIA to ask, what sensitive data is the AI processing? Is there human review? Is the decision irreversible? It's an evolution of existing privacy hygiene.
So the AIA is the diagnostic tool. What are the practical guardrails companies are putting in place to mitigate that 10% data leak threat we talked about earlier?
The first and most critical guardrail is policy. Pure and simple. Companies have to adopt and roll out a concise, AI-acceptable use policy. And the most important rule, the bright line rule, is simple. No confidential inputs into public generative tools, period.
But how do you enforce that? A policy is just words on a page.
This is where tech controls come in. Compliance teams are using data loss prevention, or DLP, tools, which normally monitor emails, to now monitor browser activity. They can block or flag large pastes of text into domains like ChatGPT.
So the policy has to be enforced with technology.
It has to be. And beyond leaks, you're also prohibiting sole reliance on AI for high-stakes decisions. The output is a rough draft, never a final conclusion for legal, financial, or medical advice.
What about the human element? How do you ensure the outputs are trustworthy when hallucinations are so common?
You have to mandate human verification. Every output has to be checked by a trained human who knows how to spot fabricated citations and demands real sources. This training is key.
Now, what about vendor tools? HR departments use these all the time for hiring. If a vendor markets their system as bias-free, does that shield the employer from liability?
Absolutely not. The sources are crystal clear on this. The legal responsibility to vet, audit, and monitor those algorithms remains squarely with the employer using the tool.
The deployer.
Right. You cannot delegate liability to the machine or the vendor. Corporate responsibility persists.
So what does proper vendor vetting even look like then? What questions do you have to ask?
The due diligence has to be extensive. 5 non-negotiable contractual requirements. First, understand data ingestion and storage. What data is the tool using? How is it stored? For how long?
To stop them from using your data to train their next product for your competitor.
Precisely. Second, you have to contractually require bias testing. The vendor has to prove, with auditable metrics, that the system doesn't produce discriminatory results. Third, the contract must grant the employer audit rights. You need the ability to look under the hood yourself.
That gets at the black box problem directly.
Correct. Fourth, Strong contractual protections, specifically indemnification. The vendor has to agree to absorb legal costs if their algorithm fails. And fifth, you absolutely prohibit secondary uses of your data without consent.
This all sounds incredibly specialized. I mean, who are the new professionals that are needed to manage this? It feels like you need to be a lawyer, a risk manager, and a data scientist all at once.
There's a massive growing talent gap. These roles require this unique blend of AI understanding, governance, risk, and compliance expertise, GRC, and the ability to translate abstract legal requirements into actionable technical policy.
They have to speak code and legalese at the same time.
Exactly. This is why we're seeing new certifications emerge, like the Artificial Intelligence Governance Professional, or AIGP. It's professionalization of the field. And organizationally, we're seeing these roles land in ethics, compliance, privacy, or legal teams.
It makes sense that privacy pros are leading the charge since they already have experience with things like GDPR.
Yes, they already have the framework for assessing systemic risk related to data and individual rights. It just confirms that this AI regulatory challenge is really an evolution of the data privacy challenge we've been grappling with for a decade.
Which brings us to the core legal discoveries happening outside the governance fortress, the IP wars, and the shifting landscape of liability. For any creator or company using AI to generate content, the big question is, who owns the pixels?
And that question leads us right into a paradox in U.S. law, the copyright paradox.
Okay, what is the paradox?
It's simple. AI creates content, but copyright only protects human creativity. In the U.S., only humans can be authors. The Copyright Office confirmed this in 2023. So if you just type a simple prompt, a cat in a space helmet in the style of Van Gogh, and take the result, you can't claim copyright on that image.
So I could spend thousands of dollars generating images for my new product line, and the law just considers them uncopyrightable raw material.
Pretty much. Unless you can prove you added a substantial amount of your own human creative input. Editing it, combining it, a really complex, iterative prompting process. The instantaneous output itself is generally considered unprotected.
But the IP wars get way bigger than just individual outputs. They center on the training data itself. This is where it gets really messy.
This is the existential threat to the whole generative AI business model. Most of these models are trained on massive data sets scraped from the internet, which includes millions of copyrighted images and text used without consent or compensation.
And this is leading to major legal battles. What are some of the big ones?
The biggest one right now is Getty Images suing Stability AI. Getty claims millions of their images, many still with visible watermarks, were used to train the model. They're arguing direct copyright infringement.
But the defense is that training is fair use, right? That they're transforming the image into mathematical knowledge, not just reproducing it.
Exactly. But Getty also has a second theory, especially relevant in the UK and EU, involving database rights infringement. They argue Stability AI used Getty's curated database structure itself, which is also protected IP. If a court agrees, it changes the entire foundation of AI development overnight.
And the other big lawsuits involve branded characters.
Yeah, the giants. Disney and Universal are suing AI image platforms, arguing that the AI lets users create derivative works that are way too close to their characters. Elsa, Darth Vader, you name it. The argument is the AI isn't just learning a style, it's reproducing proprietary output.
While that battle rages, the entire legal framework for liability is changing, especially in Europe. We have to talk about strict liability.
We already established that proving negligence is hard with a black box, so the law is evolving to make sure victims can still get compensation, regardless of fault. This is the liability hammer.
So how is the EU adapting its laws for this?
They realized their old law was obsolete. The old product liability directive from the 80s didn't clearly cover intangible software. Courts found that a standalone app wasn't a product, which left this huge legal gap.
So a physical robot arm with buggy software was covered, but a standalone medical diagnosis app that gave flawed advice might not be.
Precisely. To fix this, the EU enacted the new Product Liability Directive, or new PLD. It explicitly extends strict liability coverage, meaning no fault needs to be proven to software and AI systems, both embedded and standalone.
That's a game changer. It means AI developers are strictly liable for harm caused by defective software, even if they acted with reasonable care.
Absolutely. And it introduces a critical element to deal with the black box: presumed defectiveness. If the claimant can show the AI caused harm and the company refuses to disclose necessary information, the AI is presumed to be defective. It reverses the burden of proof.
That confirms what we were saying earlier. Governance is now a legal standard, not just a best practice. You have to document everything.
And we should mention how hard it is to get consensus on this stuff. The EU had another proposal, the Artificial Intelligence Liability Directive, the ALD.
Mm.
It was supposed to handle fault-based claims, but the Commission withdrew it in February 2025.
Why?
They cited no foreseeable agreement. It just shows the world prefers adapting existing product liability rules rather than creating entirely new rules for negligence in AI.
So, if liability is shifting, what about the person who's actually harmed? Can they easily get redress?
This is a major structural flaw right now. We call it the redress gap. Even the EU AI Act, which is the most comprehensive regulation out there, does not provide private rights of action for individuals.
Wait, hold on. The biggest AI law in the world protects against risk, but doesn't give me the right to sue if that risk actually harms me. How do I get justice?
Exactly. You're left with existing national laws, which we know are hard to use because of the black box problem, the huge gap.
So what are the proposed solutions to close this gap?
3 key areas. First, regulators need to establish private rights of action. But for that to work, individuals have to be told that AI is being used in the first place. You need transparency at the point of decision.
If an AI is making a decision about my job or my health, I need to know a machine is involved so I can challenge it.
Precisely. Second, establishing a dedicated AI ombudsman service, an independent, impartial body to review disputes.
I like that idea. It's a simpler path than a full-blown lawsuit.
It is. And it would also create this centralized public repository of AI incidents, so regulators could track risks much faster than waiting for lawsuits to wind through the courts.
And the third proposal?
We need mechanisms for collective redress. This lets groups of people harmed by the same biased algorithm, say, in housing or hiring, seek justice together.
Let's pivot back to the U.S., because while Europe is building its framework, the U.S. is defined by this wild showdown between the states and the federal government.
The U.S. is all fragmentation. And without a big federal law, the states have stepped up in a huge way.
And where is that leadership coming from?
Colorado. In May 2024, they enacted the Colorado AI Act, the first comprehensive U.S. state AI law. It creates specific duties for developers and deployers of high-risk AI systems. Think education, employment, healthcare, legal services.
It sounds like a lighter version of the EU AI Act, but focused almost entirely on preventing bias and discrimination.
That's the core difference. The focus is on bias. And Colorado's become the national template. Connecticut, Massachusetts, New York, they're all considering similar bills.
And Texas has a law too, right?
Yes, the TREGA, but it's much narrower. It mostly limits compliance obligations to government use of AI, stepping back from the big private sector rules you see in Colorado.
But just as the states are acting, the federal government under the previous administration signaled massive pushback.
That's the major policy tension. The Trump administration signaled a permissive approach. They issued the Removing Barriers EO and were thinking about creating an AI litigation task force. Their whole goal was to kill the state patchwork.
How would the federal government legally kill a state law like Colorado's?
This is where we get into a really specific legal doctrine called the Dormant Commerce Clause.
Okay, break that down for us.
The Constitution gives Congress the power to regulate interstate commerce. That's the Active Commerce Clause. The Dormant Commerce Clause is the implied flip side. It prohibits states from passing laws that excessively burden or discriminate against interstate commerce.
So the federal argument would be that if Colorado requires every software company to comply with its specific bias rules, that places an unconstitutional burden on national trade.
Exactly.
Yeah.
The argument is that one state's law can't be allowed to govern AI development for the whole country. It's the ultimate showdown. Should innovation be federally unfettered, or should rights be protected at the state level?
And that leads to our final massive headache, the challenge to the bedrock of the internet, Section 230.
Section 230 is that shield protecting platforms from liability for user-generated content. It's why YouTube isn't liable for every video someone uploads.
Right, but generative AI breaks that model. It's not just a passive host of content.
That's the key question for the courts. Generative AI creates the content. Does that make the AI the content creator, or is the platform just a neutral tool?
If the AI systems are deemed information content providers, they lose Section 230 immunity. They become legally responsible for everything they output.
And if that shield is narrowed, the entire startup ecosystem faces massive legal risk. Any company running an AI could be sued for its output. It's a huge problem.
Which brings us back to the core challenge. How do we get this right? How do we find a balance?
The path forward seems to be a hybrid tiered liability framework. one that scales regulatory obligations based on both the AI's risk level and the company's capacity, its size, and resources.
So it's proportional. The EU AI Act already sorts AI into risk tiers: high risk, limited risk, etc.
This just adds the company capacity layer. Let's use the analogy engine. Think of car safety. A huge company like Ford has to meet every single rigorous crash test and recall mechanism. High capacity, high risk.
But what about a small two-person startup making software for self-driving tractors? Also high risk, but they don't have Ford's resources.
Exactly. That startup might have more tailored requirements. They still have to meet core safety mandates, but their documentation and auditing obligations would scale to what's realistic for their size.
So you embed proportionality right into the regulation, and where do regulatory sandboxes fit in?
They're central for those small startups. A regulatory sandbox is a controlled environment where they can test new AI systems in the real world for a limited time under a regulator's supervision.
We've seen this work in fintech, right? It gives new companies breathing room to test products without being crushed by the full weight of the law on day one.
Exactly. It creates space to innovate responsibly while the public still have guardrails. It's about holding bad actors accountable while protecting ethical early-stage companies.
Okay, so this deep dive has revealed that the legal system is desperately trying to fit a square peg into an exponential hole. The conflict is everywhere in the black box, the IP wars, the battle between states and the federal government.
It is.
The solution seems to be moving from reactive punishment to proactive governance with mandatory impact assessments and a recognition that liability has to shift away from the impossible task of proving fault.
That's the crux of it. Given that governments and companies are so rapidly integrating AI into decisions that affect our lives, our liberty, our livelihoods, will this fragmented push for governance succeed in protecting our rights before these systems become too entrenched to change?
That is the ultimate question for everyone listening. If an algorithm made a mistake about your life, wrongly denied you a job, or alone what system of redress, out of all the options we talked about today, would you trust most to help you fix it? Would it be a lawsuit against a black box? Or a simple, independent AI ombudsman? That is definitely something to mull over.
Food for thought indeed.
This has been The Deep Dive. Thank you for joining us.